Great.
Welcome to today's conversation. I'm Rick from Chenaur Injury Lawyers, and with me is Mallorie, our medical malpractice intake specialist. Mallorie has her JD and graduated from Stanford Law School, one of the most prestigious law schools in the country. She's the person you'll often talk to first if you call us about a medical malpractice case, and she's here today to share how to prepare and organize your information so we can best evaluate your claim. Mallorie, thanks for being here.
Thanks so much for having me, Rick. I'm really glad we're doing this because I think the way that people present their information in those first conversations with an attorney can really make a huge difference in whether we can move a case forward quickly and efficiently.
Absolutely. So let's start very simply. In plain terms, what is medical malpractice?
Medical malpractice happens when a healthcare provider, so a doctor, a nurse, a hospital or clinic or other facility, fails to meet the accepted standard of care. And that failure causes harm to the patient. Now, a bad outcome alone doesn't necessarily mean malpractice. The way the law defines the standard of care sometimes differs from our common sense understanding of how we as patients want to be treated. So, in a medical malpractice claim, we have to prove both that the doctor or facility was legally negligent and that the negligence caused measurable harm.
Yeah, and that's a good explanation. That's what people get wrong most often is they go to the doctor and they believe that when they go there, they're going there for a surgery, or if they're going there for medication, they always believe that they're going to end up coming out better and that their problems are going to be fixed. And sometimes it just goes the other way. You go into a
hmm
surgery and
Yeah,
the surgery ends up bad, but just because it was bad doesn't mean that it was malpractice. It's a tough
correct. Yeah,
concept.
it is. And that's why I'm here. I'm here to help people understand the difference between just the natural failures of our medical system that are inevitable and stuff that we can actually pursue a claim against someone for because it was actually below the standard of care that we define legally.
Yeah, and I want to talk about that for 1 second because the word standard of care you hear so often, especially as lawyers, but if you believe you have a medical malpractice claim, you will start to hear that term more often, standard of care. Help people understand what that actually means.
Yeah, absolutely. So the standard of care is basically the threshold standard level of care that doctors are legally required to provide to their patients. So it doesn't mean the gold standard, right? It's not like best practices. It's basically the minimum standard
The
of how people
floor.
should be treated. Exactly,
Yeah,
not
that's
the
a good
ceiling.
way to
Yeah,
explain it because the gold standard is like the top of the profession. And we
Mhm.
don't hold all doctors to the top of the profession.
Correct.
We're holding doctors to the minimum standards in the profession.
Yeah,
And so it doesn't mean perfect and it doesn't even mean great. It just means good enough.
right.
And if a doctor falls below that standard, then we consider that their actions were negligent.
Yeah. So really, we're talking about the worst of the worst bad actors, or really just like negligent actors here. And I think that's why it's important to consult with an attorney when you think something bad might have happened and that your doctor might have done something negligent, because it's really hard for people who aren't in this area of law day in and day out to understand the difference between something that we might not be happy with, but is legally acceptable, even if we don't think of it as morally or otherwise acceptable in terms of what we want to see from our doctors.
Yeah, and if somebody wants to research this on their own, there's an RCW, which is the Revised Code of Washington, because we're in Washington State. It's 77.70. And the whole chapter talks about medical malpractice. And how do people figure out, though, what the standard of care is for the particular doctor that they're suing or the hospital that they're suing?
I think it's really tough to do as a layperson, which is why I think it's important to consult with an attorney. And the way that we evaluate that is we talk to medical experts in that field. So we'll talk to a specialist in the field where this negligence happened to see what the standard practice is and what is the minimum expectations of doctors in that area.
Yeah. What type of cases do you most often see or hear people talk about it?
Yeah, we see a variety of cases, but I see a lot of surgical errors of various different kinds, doctors making mistakes in the middle of a surgery, missed or delayed diagnoses. So, that is, for example, failure to recognize early signs of a fatal heart attack or a stroke, or missing a cancer diagnosis that should have been caught sooner. Also, birth injuries resulting in some kind of permanent disability or brain damage to the baby. Medication errors we had a case where someone was prescribed the wrong dose of medication, which caused lasting harm to them. We also see mismanagement of medications that interact with each other. So, not closely monitoring someone after receiving medications that can interact, and also failures to follow up on critical test results. So there's a lot of different types of cases that we see. Those are some of the main ones. And as you can tell, it can be maybe a little bit hard to tell which cases would make good medical malpractice cases and which ones might have problems. And so that's why I'm here to help people figure out whether their case is one that we can move forward with.
Yeah, and just to give people context, because we're in this industry and we take calls daily on this type of stuff. Out of how many cases do we actually decide we're going to take one of those cases?
Yeah, that's a great question. We take a very limited number of cases, is the answer. And so I have to decline many cases. I would say the main reason I have to decline cases, a couple of ones. One is the statute of limitations has passed. We can talk about that. The statute of limitations is really important. A lot of people wait too long to contact us, and then it's outside of the window that the law has prescribed that you're able to bring a case. And
And
so
what is that? What is the statute of limitations? What time limit do we have?
So in Washington state, the statute of limitations for these kinds of claims is 3 years from the date that the malpractice occurred. So that would be the date of the surgery. If it was a surgical error, right? The date of whatever the treatment was that went wrong. 3 years from that date to bring a suit. There are limited exceptions to that, but that is the basic guideline. And for minors, so if this happened while someone was a minor, that date is 3 years from their 18th birthday.
Yeah. So that gives them a little bit more time.
Yeah.
So why do we decline the majority of the cases that we see?
There's a number of reasons why we might decline a case. The care sometimes is not below the standard. So, like we were talking about, that legal standard is sometimes even lower than we expect it to be in our common sense understanding. So, sometimes, even though the outcome was really bad, it wasn't below the standard of care. Sometimes the damages aren't large enough to make the case financially viable. So this one is really tough for people to hear, and it's tough for me to talk about with people. But sometimes it's just not financially viable. These cases are really expensive and time consuming and resource heavy. We always have to hire experts, which costs a lot of money. And so sometimes the costs of bringing a claim just outweigh the losses that someone has experienced, even when those losses are really high. And then
Yeah,
in some
and
cases, oh, go ahead.
I was just going to say we've been trained as plaintiff lawyers to not take cases where the damages don't exceed a certain amount because the defense lawyers and the doctors and the insurance companies, they have unlimited budgets. And early in our career, I remember Angel and I would take a lot of medical malpractice cases that had less than a value, maybe under a $200,000 value. Maybe we would take cases like that, or even under 500,000 in value. And we would be faced with massive defense, unlimited budgets, experts. They would name 12 experts, and we would have to sift through and depose these experts to see what they were going to say. And sometimes the cost of just deposing an expert was $5,000. So we found ourselves in $50,000 in costs, $100,000 in costs, and it just didn't make financial sense. Like we didn't have the resources to pursue a case like that if the damages weren't substantial. And in
Yeah.
addition to that, there's the win rate at trial for medical malpractice cases very low because, and reasonably, people trust doctors are held high societally, and the profession is revered in as it should be. It's very difficult to become a doctor, and most doctors are out there trying to do the best they can. Sometimes they make mistakes, and juries often will side with the doctor if it's a close call.
Yeah, that makes
You
sense.
know?
Yeah, and I like to tell people because I unfortunately have to decline so many cases every day, every week. And it can be really hard for people to hear that they don't have a medical malpractice claim when they've clearly been harmed by the medical system. And so I just want to make it clear that medical malpractice is a tool and it is limited. And whenever we're not able to take someone's case, I always try to provide them with other options for holding physicians accountable and attempting to repair some of the damage that was done because a case may not be a good candidate for medical malpractice, but that does not mean that what happened was okay or acceptable. And there are other options often for people to resort to in these really terrible situations.
Yeah. I remember getting calls when I was doing a lot of the intakes as well, and there would be 5 or 6 different complaints that the patient potential client would talk about, and it'd be all over the place. It'd be like, "I went there and the nurse didn't give me the medication that I needed, and then the next nurse came by and he or she forgot to do this, and then the doctor was so rude." And so this whole experience was a terrible experience, and then at the end, he got an infection and it ended up really bad and something else bad happened. But it's hard to sift through all that because there's so many different little events that the potential client is talking about, and it's hard to identify what's the actual negligence of the medical professional that fell below the standard of care. And in
Hmm.
addition to that, was that particular negligence the cause of your injury? Because
Right,
sometimes that's sometimes a nurse will fall below the standard of care, but he or she didn't actually cause the injury. They were just
right.
rude and they just didn't do what they should have done. Yeah.
Yeah.
Talk
No, and
talk
that's a
about
great.
how yeah, so talk about what should somebody do when they're putting together the information that you need in that first call. What should they do to organize themselves?
Yeah, it's a great question. And I think what you were saying, Rick, is one of the really big reasons why it's important to be organized when you talk to an attorney, because we do see so many of these cases. And when you're all over the place, it makes it harder and more time consuming for us to assess your case. So having that really well organized up front is helpful. The way that I would recommend doing that is putting together a folder or a binder if you have physical copies of things, or saving things digitally is often even better. We can go even quicker with digital files and get gathering all of the evidence. And so the evidence means medical records, right? Test results, if there are labs, imaging, pathology reports, those kinds of things. And when I say medical records, this can include things like your discharge summaries or after visit instructions, which are sometimes maintained on an online portal. But really, the important piece of that for medical records is the records that you actually have to call and request from the facility. And sometimes people don't understand that. What you see online on your portal is not the full picture. And so when you're getting these medical records ready to communicate with an attorney, you want to call the facility where the treatment happened and actually request your official records. Sometimes you'll have to fill out a form. Each facility is a little different in their process. But if you call, they'll be able to tell you what to do to request those and get all of your records from when your symptoms started before the malpractice happened, all the way through the treatment, the surgery, whatever it is, and then any follow ups after the fact, also, including any visits with second opinion doctors, right? Which I always recommend that people get second opinions. So that's really important. The medical records, that's one of the most important pieces because once we evaluate your claim after that first phone call, if we believe it's potentially a valid claim, that's the first thing we're going to want to see is your medical records. So getting those together in an organized way is really helpful. A binder is really helpful because you can use tabs to organize everything or saving it digitally so that you can easily send those out to our team.
Absolutely. And the other thing that I love to see, and sometimes can be difficult for people, but I love to see it if they can get it done, is put together a written timeline of the medical events that led to the medical malpractice and then the events that followed the medical malpractice. And part of the reason that's good is it forces the person to be clear and organized in their thoughts, which again, we're going back to the phone call where they're complaining about this and that, and understandably, but it makes it difficult for us as we're trying to evaluate the case to actually put together sense of everything that happened.
Absolutely. Yeah. A timeline is really helpful. It's actually pretty rare that people do that, but I would absolutely recommend it. The times that someone provides me with a typed timeline of it, and including specific dates is really important, both for the purpose of making sure we're within the statute of limitations, right? But also because the specific date that a visit happened with a physician and the specific date that a certain symptom appeared, those little details can be really crucial later on. And even just in the initial phases of deciding whether this is a strong medical malpractice claim. So having that written down in a timeline, sometimes people will keep a journal and write down their memory of what happened after a visit, right after the visit happened. The closer in time that you can write things down after something happened, the better. Because memory can be foggy, memory is finicky. Even when you think you remember something really clearly, it can be a little different than what you remember. I've had people who told me that a symptom appeared after a surgery, but then I look at their medical records and it shows up earlier. And that's something that could mean that it's a make or break in the case. And so those are really important details to keep straight. So definitely having a timeline is really helpful.
Yeah, and I think the other reason why people should do that, just as a matter of practice, is sometimes you'll have to go through 3, 4 attorneys' offices and present a case before you find somebody who will take it. And like we were talking about earlier, attorneys deny these cases for various different reasons. But
Mm.
sometimes it's a good case, but they just don't have time for it. Because
Absolutely.
if you're a lawyer and you're taking medical malpractice cases, I can't imagine being able to juggle more than 4 of these at a time. So sometimes you're just maxed out in capacity and you can't take anymore. So just because you go to a lawyer and they can't take your case doesn't mean that it's not a good case, because it could be. But having this type timeline, you could submit it to multiple different offices and get a shotgun approach, at least to some degree.
Absolutely. And I think that's really important because I don't think people, until you're in it, you don't really understand the emotional toll it takes to retell your story to 12 different lawyers. I have
Yeah.
people, and we've taken cases of people who have gotten 5, 6, 7, 10 no's before they come to us, and then we'll take their case. So it really does, different attorneys have different criteria for the cases that they're able to take. And yeah, having something that's really easy to just send off to someone, even a written timeline is helpful. And even like a written short summary that you can copy and paste into different websites of different attorneys is really helpful because it's draining. You have to think about yourself and your own emotional health during this process. When you've been through something traumatic, talking about it over and over again can be re-traumatizing. And so having that prepared in advance is also really helpful for you as the client to not overdo it and drain yourself early in the
Absolutely.
process. Yeah.
Yeah, and to talk about that as well is when you're looking for a lawyer to handle a medical malpractice case, not all personal injury lawyers can effectively take on a medical malpractice case. Just because they've been doing personal injury, even if it's for a short time or a long time, they may not be equipped to take on a case. So they could listen to the facts of a case and they can believe that's a case, but if they haven't had a lot of experience doing medical malpractice cases, they they may not know how difficult it is. So we see a lot of cases that have come from lawyers where they've taken on a case and they've held it for a year and a half, and then all of a sudden they withdraw from the case
Yeah.
because
And
yeah, go ahead.
I just want to say, I think that's one of the things that I think this makes our firm a little bit unique in that we do spend a lot of time on this initial review process before we sign someone up. And I think that's important because we want to make sure that we have the resources and the evidence to make a strong claim before we put you through the process of signing you up and continuing to work with you. And we dedicate so much time and effort to each case. Some lawyers, like you said, will sit on a case, and that's because they have so many cases in their queue that it might take them months to even look at your case. And so, something that I think is really great about Park Chenaur is that we do give a lot of individual attention to each and every case that we see.
Yeah. And I remember early on, like we were talking about early on in Angel and I's career, we would take some of these smaller medical malpractice cases. We learned a ton about medical malpractice during those years. And there were a lot of cases that no other lawyers would take that we ended up taking because either they had the experience to know that these cases are difficult and they take a lot of resources. And if the damages aren't big enough, then it doesn't justify taking the case. But there are lawyers out there that are maybe younger, less experienced lawyers who will take on some of these smaller cases, and they may end up doing a good job anyway. Because I remember when we were taking on these cases, like we really believed that our clients were wronged. And so we
Yeah.
fought hard, even though it may have not made financial sense all the time, but we almost always got recovery for our clients. Sometimes it's okay if you end up with a less experienced lawyer, so long as they're willing to fight through the process and try to achieve justice.
Yeah, absolutely. I think their dedication to you as the client is one of the most important pieces because part of being a good lawyer is the passion and the actually caring attitude that you have towards your clients that comes through in the
Yeah.
way that you argue things and litigate things. That part is really important.
Yeah. So, just as a practical matter, if somebody's coming to you with a potential medical malpractice case, how long does it take for you to figure out whether or not it's a case that we're willing to take?
It really varies. Some cases can be reviewed in a matter of days or weeks, but many do take longer because we often need to consult with outside medical experts. Like I said, we consult with experts to determine what the standard of care is in a given field. We are the legal experts, but we often need to go out of house to talk to someone in the medical field who can give us a little bit more insight about a specific area of medicine that and how that interacts with the law. These are really complex, expensive cases, and it does take time to review them to make sure that we are confident that the evidence is going to support the case moving forward before we agree to represent someone.
Yeah. And how about in terms of experts? So, like, you get a set of facts from somebody who believes that they've been wronged from a medical malpractice claim. And let's say you want to talk to a medical expert in the area of expertise that the client or potential client believes that they were wronged. How much do experts typically cost to discuss their case?
That's a good question. It can be a big range because we have connections to different experts. We sometimes can find experts who will do an initial review for us for a little bit less money. So we sometimes can work with people who have a very limited budget because I tell people this is the only point in the process where we might ask the client to pay for this part of the review. Once we take you on as a client, we are able to front all of the costs before going to trial or anything. But before we agree to take the case, we do need to make sure that the medical pieces are clear. And I would say anywhere from $500 to a few $1,000s for that initial review, depending on how specialized we need the expert to be.
Yeah, and just a word of or just some knowledge for the people who are looking to bring a medical malpractice case. When we do these initial reviews, they're pretty general, and sometimes they do not become the testifying expert in your case. So just because they say, "Yes, I believe it fell below the standard of care," if it was like a review for $500 to $2,000 like you're talking about, Mallory, that particular review, once we get all the medical records, all the evidence together, and we submit it to the actual testifying expert, sometimes the testifying expert says, "Actually, I don't think that there's a standard of care violation." And that happens too, which is unfortunate, but it definitely happens.
Yeah. And it's a testament to why that initial review is so important. At every phase of this process for medical malpractice, something could come up, a new fact could appear that really changes the course of the case. And that is an example of one where you might have an expert who says, actually, this piece of this means that this is no longer a viable case. And so that's always a possibility. But that's why this initial piece is so important to make sure that we have at least a good groundwork and basis to move the case forward to the next
Yeah,
step.
and I want to talk about one other concept that I think people have a very difficult time understanding, and the concept is causation. But can you talk about that a little bit, and can we work through why people have a tough time understanding that concept?
Absolutely. Yeah. Causation is a really tough concept for people to understand. I think because the legal standard of proof is so high. And so when we say the standard of proof, that's the amount of evidence that we need in order to legally prove that something happened. So we might look at something and our common sense says, absolutely, you had the surgery and now you're having this symptom that you didn't have before the surgery. Obviously, the surgery caused it. That's our common sense understanding.
Yeah.
But the law requires more than that to be able to prove that something happened. And if you think about it, it makes sense because surgeries do go wrong. Even when the doctor does everything right, a surgery can go wrong. There's always risks associated with surgery or any kind of medical treatment. And the court is going to require that we prove that it wasn't just a standard risk that is associated with any kind of surgery and it just happened because these things happen. We need to be able to show that there was some negligence that actually is linked directly to the symptoms that we're talking about that are long lasting.
Yeah. So I think that's the difficult part. Like the example you gave where there's a surgery and then after the surgery there's a particular symptom. And if there was negligence in the surgery, then of course it caused the damage or symptom that you're experiencing now. Common sense would link those two together. Even though the burden of proof is just more probable than not, it's still very difficult to do because, like, let's say you go in for a back surgery because your back's been hurting, and then we identify that in the back surgery, they did a technique that is below the standard of care that people don't do anymore. And that's been ruled below the standard of care. And then after the surgery, you get some other symptom down your leg or something like that. And so you've got negligence and then you've got an injury. But it does not necessarily mean that just because they used a different surgical technique that's below the standard of care, that surgical technique is the reason why you're having this leg pain. Because
Right.
it could be for another reason in the surgery that was not below the standard of care. So it could be for some entirely different reason. So actually going and proving and saying it's actually this particular surgery that typically causes a leg injury, which is why it's below the standard of care, making that
Hmm.
link is difficult.
Yeah. And that's why experts are so important to comment on those things because they need to actually look at what happened during the surgery and try to identify what caused the current symptoms, which is sometimes really difficult, even for a doctor who's an expert in their field to identify what happened there. and what was the cause.
Yeah, and sometimes the very fact that you have back pain going into the surgery, that could end up with that leg pain later on, even without any negligence. It could just progress to there as well.
Yeah,
But
and that's a piece that's in almost every malpractice case that you have to grapple with because almost always there's some pre-existing symptom, right, that you're being treated for. And so the defense is always going to try to argue this was just a natural progression of this thing that you already had happening. And this becomes especially difficult when you have people with other pre-existing conditions. And so one of the things I'll ask you if you come to us with a case in that initial phone call is if you've had any other major surgeries or conditions prior to this incident. And the reason why that's important is because those are things that we need to be aware of that the defense is going to try to use against you and say, this is the reason why you're having this pain now, not the negligence that happened.
yeah, if somebody's wanting to reach out to us, what's the best way to get a hold of you?
Great question. Yeah. The best way is to give us a call. You can call us at 253-839-9440. Another way is to go to our website. Some people prefer to make contact through a message first. That's totally fine as well. You can go to our website, www.parkchenaur.com, and you can submit your information that way.
Thank you, Mallory, for sharing your expertise. For anyone watching or listening, if you think you have a medical malpractice case, reach out to Mallory and then follow her advice. Get your medical records, make a written timeline, and then give us a call. Thank you.
Thank you.
Okay.